Cool. Next, so from your on your side, interesting ones because we get this all the time from estate agents, and especially the relationship between tenant, agent, and landlord, and the confusion of what this relationship actually is. So, in your particular circumstances, there was actually a slip and fall, and this resulted in a claim or basically the person falling, the tenant, wanting to claim damages back, right? Now, this can apply across many different examples. It might not be a slip and fall. It might just be something that's broken. In commercial properties, it might be loss of rental. There's a lot of reasons why a tenant might want to claim something at some point or another. But bottom line is there's a claim. And it wants to claim against the landlord naturally, but in these circumstances, the lease doesn't allow for it. So there's a nice disclaimer there, so the landlord feels protected. So what does the tenant do? Well, decides to go against the estate agent because the estate agent did not attend to the necessary repairs in order to avoid this incident from having taken place. So, Nick, what would your advice be to the estate agent in these circumstances?
So, when we are dealing with tenants, landlords, and estate agents, there is a funny relationship that exists between these three people. Okay. And certain obligations are performed on behalf of other people. But we need to first look at the core relationship between these parties to determine exactly where liability and where obligations lie. So, when you are dealing with a landlord, estate agent, and tenant, there are actually two contracts that are in place between the parties. Okay. And interestingly enough, although these parties interact with each other throughout the subsistence of a lease agreement, there is no agreement which includes all three parties. Okay. So the first agreement that exists is the one that we're all familiar with, which is our lease agreement. This agreement exists solely between the landlord and the tenant in the circumstances. The estate agent actually is not a party to this agreement in any way. And we do still see lease agreements out there in the industry where the estate agent has a place to sign this particular agreement, but that's not really appropriate in the circumstances. Your estate agent should not be cited in their own capacity as an estate agent. Obviously, if you are an estate agent, you can sign for and on behalf of the landlord. But the contracting party is still the landlord at the end of the day, not the estate agent. I also don't have difficulty with perhaps the landlord listing on their lease agreement, this will be my estate agent in the circumstances, so their details are included. Absolutely no problem. But what is important to know is the only parties that are party to that agreement is the landlord and the tenant. Okay. Then there is a second contract, and that contract exists between the landlord and the estate agent. Okay, and this is a mandate which has been entered into. The tenant is not a party to this mandate in any way. And again, similarly to the lease agreement, every now and then we get a mandate which includes the details of a particular tenant in the circumstances. Again, not appropriate for the tenant to sign any mandate. Okay, the only parties that enter into the mandate are the landlord and the agent in the circumstances. And so what you can see from these two particular contracts is actually no agreement at all exists between the tenant and the agent. Okay. The agent is mandated on behalf of the landlord to perform certain duties, and those duties may include certain duties of the landlord towards the tenant in the circumstances. But it's very important to keep this in mind because the person who is ultimately responsible for the performance of the duties in terms of the lease agreement and to perform its obligations and who has the rights in terms of the lease agreement is the landlord in the circumstances. Okay. At no point can the agent take on the rights in terms of the lease agreement. So in other words, agent, you're not entitled to receive the rental. Okay. But similarly, I receive rental, I mean to take it into your own account and use it as you want. You can receive it into an account, it's still the landlord's money. But similarly, the obligations that are to be performed, although you may be a conduit to perform those obligations for and on behalf of the landlord, they're not your obligations. they are the landlord's obligations in the circumstances. Now, I've belabored that point to try and make sure that we're certain of these things, because unfortunately the truth is, in the day-to-day interactions between the parties in a lease agreement, what often happens is a tenant and an agent will end up interacting with each other far more than the landlord and the tenant. And in fact, it's not uncommon for lease agreements to run a full period where there's actually no interaction between the landlord and the tenant at all. And the full lease agreement is run with only interactions between the tenant and agent. Absolutely no problem with that. That is what the agent has been mandated to do. But where this becomes tricky is where there are problems within the lease agreement. Okay, and as Bruno's pointed out, in this particular case, we have a slip and fall, but it's not exclusive to that. This could be anything where there's a failure to perform in terms of the lease agreement. And then the parties are now looking at who's liable in the circumstances. What needs to be absolutely remembered? In our case that's being brought here, the tenant has instituted a claim against the agent in their personal capacity for failure to attend to certain things on the premises. And that is not legally enforceable in the circumstances, okay? At least from a breach of contract perspective. So when we're talking about this, we're talking about breaches of contract. There is a whole nother section of law which is called delict. Okay, this is a personal claim against someone else for a individual action. Okay, and I'm leaving that aside for the minute. So that's a whole nother sphere of law. In terms of contract law, okay, which is where most of these claims will stem. If you fail to perform an obligation in terms of the lease agreement, in other words, you don't maintain a premises. Okay, that obligation to maintain a premises remains the obligation of either the landlord if it comes to a structural maintenance, or the tenant if it comes to maintenance of use of the particular premises. Okay, it must be remembered that that contract between the landlord and the tenant is the one that deals with these particular obligations. And so when a tenant, if there is a defect in maintenance or some other thing that's wrong with the premises, the tenant's remedy is against the landlord in the circumstances. A failure to perform any term in terms of the lease agreement is between those two particular parties. Okay, so the tenants must take out their remedy against the landlord for whatever the default is. The landlord in turn has a remedy. Okay, so say an obligation was given to the particular agent in the circumstances and the agent didn't perform their duties. So say they were mandated to make sure that the premises is up to date. Okay, and they failed to do that particular duty even though they could have. The landlord in the circumstances then has a commensurate claim against the agent, which they should express. Okay, but there is absolutely no relationship between the tenants and the agent. There's no contract between the tenants and the agent. So it is inappropriate for a tenant to seek a remedy against the agent in the circumstances for a breach of the particular contract. Okay. This obviously has some considerations for the facts of a particular matter. So if the agent is unable to perform their obligations in terms of a mandate because either the tenant or the landlord in the circumstances does not make them able to actually perform those functions, there may be other considerations to take into account. So remember, an agent is only expected to perform those duties that are set out within the mandate that they have with the landlord. Okay, and they are only expected to perform those particular obligations to the extent that they are assisted by the landlord. Okay, so an easy way of giving a demonstrable example of this is if there is some defect on the particular premises, the agent performs their duties, they go and they find someone, they find out what the problem is, they find someone to fix the problem, and they send that information to the landlord and they say, listen, can we go ahead and approve this person to go fix this problem? If the landlord does not come back, does not give a confirmation, doesn't give the go-ahead, okay? Remember, the agent cannot act by themselves. They are only entitled to act as instructed by the landlord in the circumstances. So if the landlord does not come back and give them instruction or tell them to go ahead, or it's not already encompassed in the particular mandate, okay, the agent's hands are tied. And you cannot hold the agent liable for that failing. The failing is, in fact, then the landlord's, because the landlord didn't give instruction for the thing to be remedied, whatever that particular thing is. So it's an interesting relationship between these three parties. But what must be remembered is the two different contracts and where the obligations lie. They're always going to lie in terms of the contract, and they may play off one another. Absolutely, the agent's failure in terms of a mandate may mean that there's a claim in terms of the lease agreement. That is absolutely possible. But the parties to these contracts must remember who exactly they've contracted with and who exactly their obligations in terms of those contracts lie with.
Thanks, Nick.
Perfect. Thank you, Bruno. And we will see you again next week.
Awesome. Have a great one.
All right. Cheers.
Cool. Cheers.